Hey guys, David here. Welcome to Digital Outlook, where you're gonna find the best community in all of crypto. In today's video, court order settlement discussion. So guys, without further ado, why don't we get to it? So guys, as you know, this ecosystem is all abuzz over Judge Annalisa Torres' decision to deny the SEC their interlocutory appeal, and this is a big deal. Now, as I promised earlier today, I am going to do a deep dive into what this really means for you and I in this whole ecosystem, what it means for the SEC, what it means for Ripple, what is the interlocutory appeal, and what were they actually arguing over, and where do we go from here? Well, guys, before we even get there, something big was absolutely done when Judge Annalisa Torres made that decision. She also ordered that both of these guys go to the settlement table and try to work this out before it even gets to trial. Just take a look at this article right down here. Now, court orders Ripple and SEC to discuss possible settlement in today's verdict. And there you are, October 4th, 2023. And just listen to this. U.S. District Judge Annalisa Torres has mandated Ripple and the Securities and Exchange Commission to discuss a potential settlement of the lawsuit. The judge issued the order alongside her recent ruling on the SEC's request for an interlocutory appeal. According to the court's decision, the settlement discussion was scheduled to be held before the final pre-trial conference. Now, as reported earlier, the final pre-trial conference is scheduled for April 16th, 2024 at 2 p.m. Notably, the parties and their counsels are mandated to hold a physical meeting for at least 1 hour in order to discuss a potential settlement. Prior to the final pretrial of the conference, counsel for both parties, along with the parties themselves, shall meet in person for at least 1 hour to discuss settlement of this matter, the court ordered. Now, guys, this is a major deal. I mean, here you had the SEC filing for an interlocutory appeal. Now, what is the whole deal with an interlocutory appeal? Guys, what they were actually appealing is the summary judgment that Judge Annalisa Torres came out with and said, hey, XRP in itself is not a security. And the programmatic sales in the secondary markets, those also are not securities. And of course, the SEC was asking to go and file this interlocutory appeal. Now, what is an interlocutory appeal anyhow? Well, guys, here's a quick definition of what it really is. The term interlocutory is used to indicate a lack of finality. Why? Well, because in this case, there were other facets that were still being adjudicated and going on to trial. So in summary judgment, Judge Annalisa Torres made that decision. And so that's what the SEC was appealing. They were appealing the programmatic sales of XRP in the secondary market and appealing Judge Annalisa Torres' definition of the Howey test. Now, an interlocutory appeal is an appeal of a non-final order, and that's what summary judgment is, issued during the course of litigation. The collateral order doctrine sets forth rules for such appeals. Interlocutory appeals are extremely rare, and a three-part test determines whether the collateral order exception, res judicata, or the judgment, makes such an appeal possible. The order must have conclusively determined the disputed question. The order must resolve an issue completely separate from the merits of the action, and the order must be effectively unreviewable on appeal from final judgment. So, of course, the SEC was out there and they were appealing that. Well, Judge Torres, as we know, denied that appeal. So where does that leave us now? Well, guys, it leaves us to trial. So now, guys, just take a look at this article right over here. XRP lawsuit update. Ripple versus the SEC trial date locked for April of 2024, and what to expect. Because, guys, now that whole interlocutory appeal is done, a lot of people have some confusion that, oh, well, the SEC can just file a regular appeal. Guys, they can't do that until they get an adjudication of trial and find out what's going to actually be the final verdict over here and whether or not they will even appeal that. Because as we heard just there, they are mandated to absolutely sit together physically in person and discuss the potential possibility of settlement. Now, it's my personal belief that we are going to see a settlement probably before the end of December and maybe even mid-November. But any case, and the reason I believe that, by the way, is because I don't think the SEC, after being kicked in the can 2 times, is really going to want to absolutely take this thing all the way through trial, having a lot of these folks that, they don't even want to absolutely sit on that stand. And we know who we're talking about, Bill Hinman and all these other individuals, maybe even Jay Clayton. Hey, maybe Steven Nerioff gets called to the stand. Guys, they don't want it to happen, I'm telling you, and that's why I believe we are going to see a settlement in this situation before it even gets to trial. But needless to say, the next step in this whole thing, prior to those settlement discussions, if no settlement comes about, then it's trial. And here we are, locked for April of 2024, and what to expect. So let's just take a listen here. Ripple's law journey is astonishing, as it's laid the foundation for other crypto companies. The year 2023 has proven suitable for Ripple. The SEC's anticipated interlocutory appeal met a setback and was delayed till April. Well, the appeal wasn't delayed till April. The trial's coming in April. Now the ball is in Ripple's court, boosting XRP's price. Since halving is nearing this news, XRP is already cashing on a 5% jump. However, it is less than the summary judgment, which granted it a 72% hike. As the road is still clear till 2024, many think this is the right time for XRP to capture that lost glory. Now, the United States District Court for the Southern District of New York has made a significant decision in the ongoing legal battle between the SEC and Ripple. A trial date has been set for the second quarter of 2024. This development comes after the court rejected the SEC's motion for an interlocutory appeal, a significant setback for the regulatory body. Judge Annalisa Torres, in her rejection, pointed out that the SEC failed to articulate how the court's previous ruling misapplied the Howey test. This is the entire crux of the matter. Guys, XRP in and of itself is not a security under the definition of the Howey test. I mean, we just can't make this up like the SEC wants to do as we go along. And in the Howey test, what that whole case was about someone having investment contracts for their orange groves and all of that kind of stuff. It was never the oranges themselves. It was the investment contract. And what that was, well, you and I never got any investment contract when we went out there and purchased XRP. And no, it is not comparable to a stock. Why? Because with a stock, you get voting rights. Hey, you get dividends. You literally can get shares in the company. Well, did we get any shares in Ripple when we bought our XRP? Well, of course, no, we didn't. Did we get voting rights? No, we didn't. Are we getting dividends on Ripple's, gains on their profits at the end of the year? Do we get dividends paid out to us because we bought XRP? Absolutely not. That's the same thing as going out there and buying yourself an ounce of gold. Just because you own an ounce of gold doesn't mean you get shares in Barrick Gold and get to participate in any dividends that they have to offer. And Judge Annalisa Torres adjudicated this case on the Howey test. Now, a crucial factor in determining security status, she noted that the interlocutory appeal wouldn't likely lead to a reversal of judgment, and other elements supported XRP's classification. Remember, she only looked at one aspect of the Howey test because you have to meet them all. And when she saw that XRP didn't meet that one condition, she didn't even look at the others. Now, if this was to go to full appeal and the Second Circuit looked at all of them and came back and said, hey, well, XRP doesn't meet it for this reason, this reason, this reason, or this reason, well, hey, then that's even more towards our favor, and definitely the SEC does not want that. Now, the court's pre-trial scheduling order requires both parties, get this, to submit documents by December 4th, 2023 to set the trial date. Failure to meet this deadline may delay the trial. Ripple versus SEC is a crucial case that could break the SEC's legal barriers to crypto. As John Deaton remarked, the only method to oppose the SEC is to go legal, even in the Supreme Court. And boy, has the SEC have lost multiple cases in the Supreme Court. Now, having said that, I want to point something out. Because the SEC was denied their interlocutory appeal, what does that mean for us as XRP holders? Well, guys, that means that the distinction that Judge Annalisa Torres gave XRP in July, stating that it was not a security and that the secondary sales, the programmatic sales, also did not constitute securities transactions. That means, guys, that until this whole thing gets absolutely adjudicated, it means that you and I have XRP holds on to that status of being the only digital asset in this entire digital asset space that is deemed not to be a security in federal court by a federal judge. It's the only one with that absolute guaranteed legal clarity. And guys, this case is far from over. If you think that it's going to get solved just in April, and no, guys, it's my belief, of course, that we're going to see settlement before that. But if this goes all the way to trial, I'm telling you what, this one could take it all the way to the Supreme Court. And for that entire time, XRP and those of us who hold and trade XRP, not a security, and that is good news to be sure. Now, what next for the XRP price? Of course, we have to talk price, right? In response to this news, the price of XRP experienced a notable surge of 4%. Well, I really don't call 4% a surge in this space, but when you're talking traditional markets, that's what they would consider a surge. Underscoring how legal developments can make or break prices. This is indicative of high stakes involved in such legal proceedings. Looking ahead, analysts have put forward various predictions regarding XRP's price movements. eGreg Crypto has boldly predicted a potential price surge exceeding 1,000% at 10x, envisioning XRP trading at $6.70. This projection is based on XRP's continued support above a crucial 10-year trend line. Another analyst suggests that XRP might be on the cusp of a breakout from its recent sideways trading pattern, akin to movements observed in other digital assets like MakerDAOs. These predictions highlight the speculative nature of cryptocurrency markets, where legal developments and technical analysis can profoundly impact prices. Wells Fargo manager Shannon Thorpe believes that as this sector expands to a projected $250 trillion, it could propel XRP to $500. Guys, this is going to be monumental. I mean, look, it's not just this case. I mean, I do believe that we are going to get a settlement out of this case, because I do not believe that the SEC, on top of all that we talked about who wants to sit in the Stanford trial, that they don't want to risk losing it and lose jurisdiction over the entire crypto space. Because if they settle, then hey, it's a win for XRP, but then they may be able to still go after some of these other ones. If this goes to trial and Ripple wins hands down, then the whole digital asset space, it's fair game. I'm telling you, it is a big deal. Now, guys, something that I want to bring out is how this entire appeal process works, because if we get to the end of this trial, if no settlement is done and we get to the end of the trial and it gets a judgment in favor of Ripple and the SEC appeals a full formal appeal, this is how it's going to go down. So about the U.S. Court of Appeals. Now, first and foremost, in the federal system, 94 district courts are organized into 12 circuits or regions, and the one here in this case is the Second Circuit. Each circuit has its own court of appeals that reviews cases decided in U.S. district courts within the circuit. The U.S. Court of Appeals for the Federal Circuit brings the number of federal appellate courts to 13. This court takes cases from across the nation, but only particular types of cases. Now, here, what's the significance? The Supreme Court of the United States hears about 100 to 150 appeals of more than 7,000 cases it is asked to review each year. That means the decisions made by the 12 circuit courts of appeal across the country and the federal circuit court are the last word in thousands of cases. That is a big deal. Not everyone is going to get before the Supreme Court to have their case really, really looked at. Now, I think that this one certainly has the potential that it could get there, but the Court of Appeals in the 12th and the Second Circuit actually is going to be a big, big deal. Now, how do appellate courts, how are they different from trial courts? This is a big deal. And a lot of people get this completely confused because they absolutely think that they're getting a second trial, and nothing could be further from the truth. At a trial in a U.S. district court, witnesses give testimony and a judge or jury decides who is guilty or not guilty, or in a civil case like this one, who is liable or not liable. The appellate courts do not retry cases. That is so vitally important. Or hear new evidence. Another big deal. They do not hear witnesses testify. The appeals court does not hear that. There is no jury. Appellate courts review the procedures and the decisions of the trial court to make sure that the proceedings were fair and that the proper law was applied correctly. And that is why Judge Annalisa Torres was in her right to deny the SEC their interlocutory appeal. That decision is now final. Why? Because she did not make an error in law and she did not make an error in judgment, and the SEC, the argument that they put forward was not enough to convince the court that either one of those two things happened, and no new evidence is presented. There's no witnesses. There's no trial. It's not a retrial. And that is so fundamentally important to understand what happens in appeals. Now, an appeal is available if after a trial in the U.S. District Court, the losing side has issues with the trial court proceedings, the law that was applied or how the law was applied. And that was the whole point of the SEC and their interlocutory appeal, because they were saying, hey, we think that you absolutely, Judge Annalisa Torres, the SEC believes that you applied the Howey test in the wrong way. Well, the court didn't hear it, did they? Generally, on these grounds, litigants have the right to an appellate court review of the trial court's actions. In criminal cases, the government does not have the right to appeal. Now, grounds for making an appeal. The reasons for an appeal vary. However, a common reason is that the dissatisfied side claims that the trial was conducted unfairly or that the trial judge applied the wrong law or applied the law incorrectly. And that was the whole point of the interlocutory appeal. And Judge Annalisa Torres came back and said, no, I didn't. I applied it exactly how it was meant to be applied based on all the precedents from 1940 until now, and XRP and these secondary sales in the blind sales in the secondary market, they do not constitute securities or investment contracts either. Now, the dissatisfied side may also claim that the law the trial court applied violates the U.S. Constitution or state constitution, which, of course, in this case, not even there, right? The side that seeks an appeal is called the petitioner. The side that brings the petition request asking the appellate court to review the case. The other side is known as the respondent. It is the side that comes to court to respond to and argue against the petitioner's case. Now, before lawyers come to court to argue their appeal, each side submits to the court a written argument called a brief. Briefs can actually be lengthy documents in which lawyers lay out the case for judges prior to oral arguments in the court. Guys, it is so fundamental to understand. Why is it so important to understand this whole appeal process? Because out there we are inundated with heaps and heaps of absolute FUD trying to convince you and I that this whole thing was going to get retried, and boom, out we were going to get, and on and on and on. Guys, I'm telling you, from my perspective, from what we see, that the SEC at this point, having literally been shut down twice on this argument as to whether the programmatic sales and XRP is a security, and the programmatic sales and the secondary markets would constitute investment contracts, they've been blown away twice. Guys, I do not believe for 1 second they're going to risk this thing going to trial and put all of their eggs in that basket when they could lose jurisdiction over this entire digital asset space. No, my belief, guys, is that they are going to go out there. They are going to absolutely settle with Ripple. And boy, does Ripple have some serious leverage now. And that's what I really believe is going to happen. Guys, get ready. Things are about to get absolutely wild. And I believe that before we even see the dawn of April, we are going to see a settlement on the table. And this thing is literally going to blast off right through the stratosphere. I tell you what. Guys, one of the best things that you can do for yourself in this space is to get your plan in place before this next bull run absolutely takes off. And what our coaching program offers, that is where you and I can meet personally, one-on-one for 1 hour over Zoom. And during that time, I share with you our personal journey in that last bull run and what enabled Judy and I to experience some amazing financial success. I share with you the mistakes we made so that you don't have to fall into the same pitfalls we did. We take a look at your portfolio and make sure that it's balanced towards your goals, and we work together to develop your exit strategy. We can even get your assets off an exchange and onto a hardware wallet, along with delivering to you some amazing techniques that are really going to help you in this space. Now, the cost of that is $250, and if that's something that interests you, you write me right there at coaching@thedigitaloutlook.com, and we'll get you all booked in. So guys, this is the video I have for you today, and as always, I truly hope that you enjoyed it. Now, many of you know I'm not a financial advisor, and this isn't financial advice, but if you found value in it, if you'd hit that like and subscribe, I'd appreciate it. Hey, don't forget to put your comments right down there in the comment section and hit that notification bell so that you don't miss out on any of our regularly released videos. So, in the meantime, and in between time, stay safe, be blessed, and I'll catch you in the next one.